Okay, now we're going to move back to what was item number 1, and this is a presentation regarding potential regulations of the discharge of firearms in areas of the county with high residential unit density. And John Roberts is going to go over this with us. Welcome, John.
Sure. So as a reminder, the board heard from a lot of residents back in May, June timeframe about some complaints about gunfire near their residential development, development consisting of multiple houses. And I was asked to provide the board with some information about whether an ordinance could be imposed or implemented, adopted, based on housing density, distance from houses, et cetera, to address those residents' safety concerns. And the short answer is yes. An ordinance can be adopted based on housing density, based on distance from dense urban-like or suburban-like neighborhoods. And we'll put up a diagram in a few minutes to show you an example of how that could work, what it would look like. But for the most part, well, there it is. We'll talk about that in just a minute. But what this presentation is not a recommendation or a proposal or a suggestion. It's just information for the board to give you some idea of what this would look like, and if the board wants to pursue it, a lot more work would need to go into this, and I'll explain that a little bit as I go along too. So last week you heard a lot of residents' concerns about, do we need this type of regulation? That's a policy issue for the board. You heard assertions that it's a constitutional violation. I would like to clarify that is not the case. Any one of the rights in the Bill of Rights may be regulated, as our Supreme Court has said, may be regulated as long as the regulation itself is very narrowly tailored to accomplish a specific purpose. When you go beyond that narrow focus and start making a broad law that applies, and has impacts that weren't intended, that's when it could become unconstitutional. But in layman's terms, for the most part, a narrowly written law that has a specific purpose in mind, it will generally not be considered unconstitutional. And so if you decide to do this, one of the things we would be working on is making sure that it is very narrowly focused. Durham previously regulated firearms in a manner similar to what we're talking about tonight. Their original ordinance, which was in effect up until December, focused on housing density in their approved subdivisions. I talked at some length to their attorney, the county attorney, about it, as well as the sheriff's attorney over there. That ordinance was repealed because they found that it was difficult to enforce. And it is problematic. There are some problems with it, and those would have to be worked out. And they went to a straight 900 foot from government buildings, private residences, churches, schools, no shooting within 900 feet of these buildings. And that may work for Durham County. I would suggest to you that probably would not work for Orange County because you're two different counties. Orange County still has significant areas that are rural in nature, with buildings far apart, but still 900 feet would eat into a lot of private property. In Durham, it's much more urbanized than Orange County, and so they did not experience in their December public hearings or meetings much opposition to their ordinance change. But again, they had this density restriction. You can't fire within 600 feet of one of these designated areas without a permit. And they had a convoluted permit process that required a public hearing before the Board of Commissioners every time somebody on a shooting range wanted to get that permit. and now they've just got the straight 900 feet requirement, although I think that is probably going to be equally difficult for them to enforce. So getting to the example, it's really not as big as it could be. What you see up there is a map that was prepared by the county's GIS staff, and it divides the county's rural area into 10-acre grids. You don't see the white grid squares, but you see the red grid squares, and what those are 10-acre squares that have at least 10 houses in them. And they are linked by the green lines as being, these are clusters of densely or 10-acre developments or 10-acre houses on 10-acre parcels within about 1 mile of each other. And so this is essentially what this would look like at that 10 acres and 10 houses limit. But that is just as an example, and 10 acres with 10 houses on it, 10 or more houses on it, is probably not equivalent to a suburban type density. And so one of the things, if the board wants to do this, that I would recommend is that the planning department, GIS, one of your departments that has the capability of actually coming up with what constitutes suburban type density looks at this and figures out where those areas are in the county. But if the number is higher, if, say, they come up with a number of 20 houses per 10-acre grid square, the regulated areas would be substantially smaller.
But this map showed, like the red squares on this map, excuse me, would include that areas that are more dense than 10 houses on 10 acres. So
Each red grid square represents an area where there are at least 10 houses. So it could be as many as 20.
right,
It could be as few as 10.
right.
And one thing that's not on here is this ordinance would also apply in the ETJ areas. So the light gray areas around the towns, if there are areas that have the minimum required density in those light gray areas, they also would be impacted. But GIS, at least on short notice, was not able to give me the where those grid squares might be in those areas, so I did not count those or did not mark those.
Can you explain the green line?
Say that again.
The green line?
That's just a boundary line of where these areas are. It is not, again, that's not a recommended line. If the board decides to pursue this option, the boundary line is one of the things that planning or GIS is going to have to determine, what the actual boundary is. That's on there to show you, to give you an approximate idea of what this might look like and where this would be enforceable. But an actual boundary line would have to be worked out by other departments. It's not in my area of expertise how to do that. So it could be based on roads, property lines, GIS coordinates, and we would have to keep in mind that whoever's enforcing this would need to be able to locate where these boundaries are. Again, that's something that'll take some more work.
Sally has a question.
Yeah, I think maybe you just answered it, but just to be really clear, is the idea that things like, I'm looking at that big one off the 54 there, and that however that green line gets drawn around those red quadrilaterals, that whole area would be an area to enforce this ordinance, even though the areas outside of the red boxes are probably going to be less dense than that?
That's to be determined. That's up there. They're all the clusters are approximately within a mile of each other, but would you want to include all of that using the one you're looking at, would you want to include all that empty space between 54 and
Those
that
top two,
cluster up
right.
north of that? I don't know. Yeah, it doesn't seem like you would need to, because that's greater distance than what anything we would be talking about. And I would not be recommending 900 feet like Durham's got. That seems excessive, considering we have existing restrictions based on, hunting around schools or government buildings. I believe is 450 feet. So I don't think we would want to go, or I wouldn't recommend going beyond that, since we have that, and that is statutorily authorized. So the legislature said that's okay for you to do, Orange County. So I would want to stick with that number or lower, just so that we go along with what we currently have authority to do.
So the 600 is just what Durham's model was, not what you're thinking.
Right. 600 feet is what Durham did. Now they're up to 900 feet from most buildings.
Yes, John, or staff, I suppose it would be more properly addressed to. I see the red boxes. The red boxes really mean nothing to me, except if you'd scroll down. I don't know how we scroll down that Hillsborough. I need to point out that Hillsborough section. No, scroll up. I'm sorry. My apologies. Okay. The area there in the green line to the north of 70 at Hillsborough is Church and Grove. I'm aware of what that is. I'd be interested, if and when this comes back for further discussion or whatever, I'd like each one of these red boxes to have a name on it. Or not on the map, but on a list. I want to know which subdivisions these affect. I know that's Church and Grove. I can speculate on 70 up toward Mebane, a couple of those areas. I know basically which subdivisions they are, but I'd like to know which subdivisions are going to be affected by this. Now, I think anyone would understand that in Church and Grove, out in your backyard on a quarter-acre lot, you don't go firing off on any targets or anything else. But if you move down 70, east of Hillsborough, there's another section just like the 54 section that Commissioner Green asked about. I'm familiar with that area. There are subdivisions out there that makes no sense for people to be target practicing or firing weapons in their backyards on a quarter-acre or half-acre lot. But there are also hundreds of acres in that green outline, and I know that green outline is just drawn on a map. I know that means nothing at this point. But I'd be very reluctant to start drawing lines on a map when I know there are hundreds of acres in that are going to be affected by those same regulations, although the shooting limits would be totally acceptable.
Right.
And I'll make one. Well, I'll wait and make a comment later.
Mark?
So before I ask my primary question, Commissioner McKee made me think of something. So in addition to the names of the subdivisions, it'd be really useful to have a map where we could zoom in on the road so we could get an idea of how the enforcement areas might be defined, and we'll just know better. We'll know the geography better if we have the road names there. But were you suggesting with the ETJs that work remains to be done, or was that?
Well, absolutely. So I asked for in the rural areas, but the ETJs also have some density in there. There are developments within these ETJs, and the green lines could conceivably go away completely, and you could base if you wanted to do it, you could base an ordinance just on subdivisions. If there are subdivisions that have a specific density, of one house per acre or less, and you wanted to address those and say nothing within 500 feet of the outside properties of this subdivision, that would be a method of doing this too. But the ETJs, yes, that this ordinance would apply there, and there are undoubtedly subdivisions and densities, or residential densities within those ETJ areas that would be impacted by this ordinance.
So I think we should discuss whether the ETJs should be a no-gun, a no-shot zone by themselves, since we expect development in those areas. I mean, I'm not sure the answer to the question, but I think it's worth pursuing. These are areas where we're going to have development. Do we just plan for that expected development.
Can you do that? Can you make an ordinance that only applies to the ETJs? Or does it have to apply to every place in the, uniformly across the county?
I would have to look at that further to give you an answer. I mean, just thinking about it, that sounds like an equal protection issue, but I'm not sure that it would be. So I would need to look at that some more.
But if we also saw the density in the ETJs, we could have a better sense of what was left over. And if it's very little, then the decision may make itself.
Right. And like I said, if the board decides to pursue this, you will have better data, better information before, at any public hearing we have on this, and certainly before a decision is made. This is just to give you some idea of what's possible.
And when you look at that, would you look at whether there's any implications of whether we're going to have mutual agreements with those towns in order to change something like this in their ETJ?
That's not necessary. So in the
Okay.
in the ETJs, the town's land use ordinances are controlling, but police power ordinances, the county's police power ordinances are still in effect there. I've had that discussion with Chapel Hill's attorney many times on him telling me I needed to tell a department to do something because our ordinance was being violated in their ETJ. So that wouldn't, an agreement would not be necessary.
Okay.
I think Sally and Mark wanted to.
Yeah, just thinking of the ETJ, there's a lot of, my guess is that there are a lot of properties in there that are on more than an acre because they're not on a WASA, right? So if if we could just say ETJ off limits for, the board of the ETJ is where the 450 feet starts. That's something I'll be willing to look at. I do think we need a lot more information about this, but yeah, you're not going to find houses on half acres where there's no water, there is no Awasa sewer.
Yeah, so you mentioned in the presentation the issues that Durham had with enforcement. I'm wondering if we can just talk about enforcement a little bit, how it gets enforced. I think I saw the sheriff here. Maybe he wants to talk about, so how does something like this get enforced? A neighbor calls and says, someone's shooting near my house, and then the sheriff goes out there, or how is it supposed to work?
So I've talked to the chief deputy, and the sheriff can correct me if I'm wrong, but the way it works, the deputies go out, they talk to the folks, they figure out what's going on, and before any citation would be written, they would talk to them and explain the ordinance and try to help them make sure they're in compliance or able to get in compliance. And that's as far as I want to venture down that path. If there's more to that, I think it'd be more appropriate for the sheriff or chief deputy to answer that question about enforcement and how the deputies respond.
Well, let me ask a follow-up, and maybe you're not prepared to answer this, but so this type of regulation based on density, or there would be some kind of prohibition within like the Durham one is within a certain number of feet from a building if you're in the zone.
Yes.
And that's not a question of, is it too noisy? Is it too late at night? It's simply like if you're inside whatever the designated area is, you're not allowed to shoot. And then if you're outside that designated area, then an ordinance like this that's based on residential density just wouldn't apply. So if someone lived outside one of these red zones, again, just using this for discussion purposes, and the neighbor was shooting at 3 a.m. and woke everybody up, or that would have to be subject to some other type of regulation, either a noise ordinance or something else. Is that
correct? So outside these areas, it would not apply, or outside whatever areas the board ultimately decides on, it would not apply. I wasn't quite through with my presentation but no, that's fine. But before the question started, but one of the things I was going to say is, if you adopt something with this theme of how to regulate this, as far as existing ranges that might be in there, And a range is something that the General Assembly has defined as an area that is operated or maintained, and this is paraphrasing, for target shooting. So if there are those that are in there, rather than just immediately saying, okay, folks, you can't do that anymore, my recommendation is ultimately going to be that the board adopt a permit process not as convoluted as Durham's, where you have a public hearing every time somebody wants to shoot, but an administrative process where somebody can come in and say, I would like a permit to shoot. The permit's good for a year. I'll agree that I want to only shoot between the hours of 10 and 3, Monday and Tuesday. It can be whatever is agreed to, or can be whatever the board decides it wants to restrict shooting to in those areas. So that's something else that would need to be discussed. But for existing ranges, if there are any that are impacted, I would recommend that there be some permit process so that they aren't deprived of something that they have until this point been lawfully doing. And there are some, that are in compliance with Orange County's land use laws, and I don't know, don't necessarily want to take something away that is being lawfully done to this point.
Yes, so that gets to a couple of my questions. So Durham is basically safety, distance and safety. It doesn't address noise.
That's correct. It's not part of their noise ordinance.
Right, and so what is the, I guess, I don't want to say you, so looking at this map, what are we talking about, safety, or are we talking about noise? Where there's density, is it because of the noise that neighbors would hear, or are we talking about safety? And then you talk about ranges, and then if people have all the berms and safety things in place, are we addressing that?
So when you heard from all the residents who complained, you heard some of them talking about bullets found in gutters and things of that nature. So this would be written as a safety ordinance. The noise ordinance would not be amended. If the noise ordinance were amended, it would apply countywide and would be extremely and even more difficult to enforce than this, because as Commissioner McKee mentioned, I live in one of these subdivisions, and I can go outside most days during the fall and hear shooting. It's usually far away. It's not too close, but it sounds just like home. So you may be familiar with that. Shooting is going to occur, and there's going to be hunting, which would not be impacted at all by this ordinance. The 450 feet limit would not apply to lawful hunting, self-defense, or the lawful instructions of a law enforcement officer. That's North Carolina state law says those three things cannot be regulated by the county. So even inside these zones, if there is lawful hunting going on, that's not regulatable, or it's not regulated. And same with any self-defense. If someone is accosted in their home and has to use a firearm, that obviously would not be subject to violating this ordinance. So,
and I would also echo about having a map. If we're going to come back and continue to discuss this, a map that actually shows the roads in a little more detail, because and Earl was talking about Churton Grove, or just south of 70. There are some lots that are less than an acre, and then you've got some lots that are 2 acres. And it's a mishmash, and there's a river that river goes through there, and I can tell you that somebody, on occasion, I have no idea where it is, because they're shooting and the noise just travels down the valley of the river, and there's no way of knowing where it's coming from.
So even understand that, but just as an example of the hunting issue, probably 7 or 8 years ago, the former sheriff called me with an issue and said, Mr. Roberts, what can I do about this situation? And on a half-acre lot, an individual, I think it was down in the rural buffer area, an individual had laid out bait beneath a tree, and he was 20 to 30 feet up waiting for deer to come under and was shooting straight down. And he was on a one-third, or it was not in the rural buffer, it was right outside, but on a one-third acre lot with houses all around him. And he said, what can I do about this? It was not a violation of any law, and still would not be.
Because he was hunting.
He was hunting, and he was doing it in a safe manner. He was shooting straight down into the ground, deer first. But that's an example that, hunting is not going to be regulated by this ordinance if the board decides to go this way.
And if someone has a shooting range that's like semi-commercial or business, would they be regulated?
It would. It would. I don't believe there are any commercial ranges within any of the areas within that green one on 70 there. There's a actual indoor range, but
Yeah.
I don't know of any outdoor ranges that are commercial in nature in any of these areas. And certainly, if the board elected to just regulate by subdivision, definitely there would not be any within the area. There might be some sport range or private sport range within a 450 feet outside.
That's what I was referring to.
Okay.
Private sport range.
Right. So within these green areas, there undoubtedly are. But again, if you try to do this by subdivision and limit it to 450 feet around each subdivision's outskirts, there would not be any within those areas, but possibly would be something outside that was impacted.
Okay, and my final question, can we regulate the types of firearms that are used?
The types of firearms,
Like an AK-47, something high capacity, all of those?
no.
Military style?
no, I don't believe so. There is a distinction in state law for some things, but I don't believe so. I will look into it some more to verify that and let you know.
Would you see any legal impediment to regulating it so that the subdivision happened to be houses that are on 10 acres each?
Would there be an impediment to that?
Yeah.
Well, if you're looking at regulating based on a suburban type density, that would not be consistent with that definition. And I believe that for this ordinance to be, entirely lawful, there needs to be designated criteria that we can point to as the reasoning behind the adoption of the ordinance. That being dense areas that need a greater level of safety with firearms discharge nearby. A subdivision with 10-acre lots might not fit within criteria. But I don't know if there's a legal impediment if that is the criteria that's adopted.
Okay. I'm just trying to think out loud here. These are homes that look like it looks like a subdivision, and it sort of feels like a subdivision, except that the lots are very, very large.
Right. So if it's a designated subdivision, I'm going to recommend that if we do the subdivision route, that it also have a density requirement, and the board can adopt that or not. If it's a 10-acre lot subdivision, that perhaps it is something the board wants to look at.
So I'd like to hear more about why it's so hard to enforce again, or whether it's the noise ordinance or this, and maybe again if the sheriff wants to weigh in, right? So, I mean, why can't in the First Amendment, you can have time, place, and manner restrictions, right? So if someone is shooting, in the middle of the night or at 4 a.m. on Sunday morning, and, why can't we have restrictions on that, and why can't we enforce them if we have them?
So this whole topic has got to be carved into about 4 different sections: noise, safety, hunting, and those other regulated matters. The problem with noise, Commissioner Dorson, is that it occurs and it's over instantaneously. If it's prolonged, that gives us an idea of where we're going. As far as why it's problematic for us to enforce, we are finding ourselves wandering onto people's property with no lawful authority to ask them if they're conducting a some lawful practice. If they are firing a gun in a lawful manner, now you have an officer with a person on their property with a firearm conducting lawful exercise, and if there's an argument, the officer is now in a perilous point, and somebody's going to get hurt. There are instances when we respond to residences and we encounter folks who are firing in a safe manner, and we have a very good, cordial conversation, and that's generally the case. But when we're placed in a position of having to wander about and look for where this sound occurred, it just creates an opportunity for a problem to occur. We have, and Mr. Roberts and I have talked over the years, even back to when Sheriff Pendergrass had asked for him assistance, about how we could discuss the noise issue. And what we have found, it is very difficult across the state. We've called other counties and across the nation, rather, about how they enforce noise with respect to firearms. It's very difficult to enforce. With respect to the safety, we've taken measures to go down that road. And, we had the firearms committee, and we dealt with that. And I think we dealt with it in a very appropriate manner. With respect to the gun ranges, there are no commercial gun ranges that I'm aware of that are outside. Those gun ranges that are in the county have proven to be safe because there have been very little or no instances of anyone becoming hurt at these ranges. That doesn't mean it cannot occur. We understand that. I talked with the former Durham County Sheriff who operated under this ordinance when it first came about, when the commissioners wrestled with this division of distance, and they landed on 600 feet. 900 feet was what they had talked about, and there were a lot of reasons why they chose the 600-foot line that they would need to speak to, not to me. The problem with that is when you talk about safety, that's cut and dry. You know whether it's safe or not. This was done in an effort to reduce the noise created by these ranges or these areas where folks were shooting. The problem that the sheriffs have told me that they've dealt with is that here is okay. And there's the line. Here is not. How do you explain that to the neighbor that lives here? That's problematic for us because now we're in an argument with the landowners as to why one can do something that one 6 feet away can't do. So it's way too premature for me to comment on how this ordinance might be enforced. I have had a policy since I've been in office that I don't talk about legislation before it's signed into law. I won't discuss this policy here until it's signed in as an ordinance. I can talk and give my advice as to how I feel these matters might work their way through, but that's kind of the limit of what I can do until I know exactly what it looks like. I think Mr. Roberts has spent a lot of time trying to figure out how to make shooting safe in this county, but it's not going to stop the noise. And the other part, the fourth part that's got to be carved out of this conversation is that of gun violence, because this ain't gun violence. And I know there are folks out there who are very passionate about gun control and removing guns from the world. That's not what this ordinance is going to do. This ordinance is going to create a safe environment for folks who live close to these areas such that it can be regulated in some type manner. And as for how the enforcement of it will occur, the deputy will respond. If they note a violation, they will make the charge. As Mr. Roberts said, we would first ask them to curtail. If they don't, of course, we could make that charge. It would go to court, and the district attorney would be the one who would be responsible for prosecuting the case.
That's very helpful. Thank you. I appreciate that input.
Yeah, John, you had mentioned you weren't finished with your presentation. Do you want to go ahead with that? I'm going to actually make a comment.
I think I squeezed in, let me make sure. I think I squeezed in everything else. Only thing I wanted to reiterate is just an example. There's some research involved in this, but a lot more would need to be done to come up with actual criteria that could be used to lawfully adopt and impose an ordinance. So we would need more work from GIS, from planning, and the sheriff. We would need to know what's the most effective way for the sheriff to actually enforce an ordinance that's adopted, because if you adopt something that can't be enforced, it's a lot of work for nothing. And I want to avoid that. So if the sheriff, if we can work with the sheriff and find out what exactly will help make this a more enforceable ordinance, that's one of the other things we would need to be doing. So we just need direction from the board on how you want to proceed, and we will tackle it as best we can.
Earl, can I ask one technical question before your comment? Just one more.
No, sir, I'm in no rush.
I just had a question about the sports shooting range or the shooting range. I was reading the statute that you gave us. It's not clear to me what that definition actually means. Does it mean something formal that is established where people go, other people come to the property and shoot? Does it mean if, my neighbor has, targets set up in her yard and goes out there every, Saturday and shoots for a while? Is there some specific definition of what constitutes the statutory exemption of a sport shooting range as it's described here? It's not clear to me.
So there is no court interpretation that I have found of what sports shooting range means. Sports shooting range or range is defined as an area designed and operated for the use of rifles, shotguns, pistols, silhouettes, skeet, trap, black powder, or similar sports shooting. So what that is not, I'm comfortable saying that is not somebody going out and putting up a target on a tree and shooting at that. That is inherently dangerous, because when you miss that target, if the tree doesn't catch it, whatever's behind that tree is gonna. So that's not a sports shooting range. That's not a range, but an area designed and operated for this use. And that's a very broad definition. And so I've interpreted it broadly as it's written, and I would think that would be something with some safety barrier that's been erected, to some long area that's got shooting lanes or something of that nature. But again, it's a broad definition, and there has been no court interpretation of what specifically it might be.
Yeah. As most of this board has sat through this discussion before several years ago, and I and former Commissioner Barry Jacobs co-chaired a committee. The members of that committee ranged from one member that would have probably taken up all the guns and melted them down, and on the other extreme, a member that was absolutely, adamantly opposed to any type of control, regulation, et cetera, at any point for any reason. But we wrestled for several months over many meetings with what to do about the situation at that time and how to address it. What we were able to do was make changes related to safety. What we were absolutely unable to do, as most of this board is aware, was to address noise. We couldn't even define noise, nor could we agree with what amount of noise, what level of noise, what frequency of noise was annoying to each one of us. So we finally gave up on noise. There was no solution that we could find, and it was absolutely not for lack of trying. Now, I occasionally shoot skeet out on the farm. I make sure that we're shooting in a direction there's no houses. I'm right out in the field beside my house. But I got a neighbor right across the yard, right across the road. I'm sure that if he's having a family reunion on the day that we choose to shoot skeet and I don't know about it, we're aggravating him. I got no doubt about it. Because I've got another neighbor that shoots occasionally at 10 o'clock at night, and it aggravates me. That's just pure disrespect. I am very concerned over developments like Church and Grove and some of these others up on 70 and down around Chapel Hill, because like I say, I've got no use for somebody to go out on a half-acre lot or a quarter-acre lot and start shooting. I don't care if he's shooting straight down in the ground. But at the same point in time, I don't know how to address this piecemeal. I look at this as totally unenforceable. And I'm speaking to the board. I just do not think that I could. I would really have to see some regulations that I felt was enforceable and reasonable. And I don't see a combination, having sat on that committee, of anything. And one thing I should have thought to ask and would have been good to have in this packet in any further discussions, we need a copy of our ordinances. Because off the top of my head, I cannot recite those ordinances myself, and it's been about 3 years. But nothing that I see in this packet and nothing I've heard is going to address noise. And I think that is a driving, except for a few people that would, have one side or the other. I don't see anything at this point that I think would be reasonable or enforceable.
Okay, well, I have written down about 9 different steps that have been recommended, which include definition, suburban density, ETJ follow-up, safety versus noise, ordinances, how do you search for sound, overall enforcement, and additional maps that include the different subdivisions and perhaps blow-ups where the streets are, and anything additional that I didn't cover?
Well, I think not just blow up maps, but what we ought to be able to do is just pull up the county GIS for the next discussion, and we could zoom in to any of these areas.
Okay.
I think.
Let's do that. That's a good idea.
I mean, I think this question. It sounded to me like at least if there was any consensus emerging, it was around these higher density subdivisions, and some of the ones that have been pointed out, and there's some other ones, in the southern part of the map you can't see right now, and then also looking at the ETJs for those same things.
I have that ETJ.
So I mean, as far as, I don't know that there's any more. I was asking the questions about enforcement. I don't know that there's anything else to hear from what we heard already, but except in this context of, if we go this subdivision route or these higher density areas. I don't know.
Right, and I think the sheriff said that he's not going to make comment until there's a policy. So that would be up to us to create the policy, then he would create the enforcement. But I don't think we're at that phase. I think we want to continue the conversation, and we want to. Again, I have about 9 steps here, and John and I can go over them, and I'm sure you have notes on that. And how does this conversation continue? Does it go into another work session? Does it become an agenda item? How do we continue with this?
Well, I haven't really heard any firm direction, so if anything, it would be.
Well, I got a couple of steps here that there is some direction on.
Well, I was going to say that no firm direction to bring this back as something to vote on, so it would most definitely be a work session item. At some point in the future, I don't know how long it would take GIS staff to come up with what I've heard tonight about blow-up maps for all of these subdivisions. There's a lot of subdivisions in there, in these areas. And if you get down to the road name level, that's going to be a lot of different maps within just the areas around Hillsborough and Eflin, Mebane. There's going to be a lot of different pages to look at.
Okay, Mark?
In the interest of moving it along, what if we took just 3 or 4 prominent dense areas and looked at the maps of those, and then we could discuss in principle what we learned from that. And then, if need be, we could move on and get maps of all these other areas.
And that's a good suggestion. And one of the things I should have thought of this sooner. It's probably a good idea for planning or somebody else to come up with an actual density of what suburban density looks like, because this is not ever going to reach the levels of urban density, any of these areas, but they are more akin to suburban density. And if that's what we're basing this on, then if they can come up with that, we can pull some subdivisions that meet those criteria. And depending on how many there are, we can give a list for the board to think about.
You did actually come up with that. You said that we should talk to GIS or planning and get a definition for suburban density. So you did say that.
Things go in and out.
Yeah. Renee?
The other thing too on these, if you do decide to take 2, 3, 4 samples, subdivisions such as Churton Grove, Asbury Crossing, I mean, those are new. They're well defined, but there are other areas that are older neighborhoods that don't have that same kind of cookie cutter pattern where you've got 3/4 of an acre and a house. Mm-hmm. We got some of those areas are really dated. They go back like 50, 60, 70 years, and you just don't have that same pattern. But they, in some cases, they would meet. You might want to consider them dense, but you just go down the road and it's no longer really dense. So I would be interested in at least seeing one of those and how that might be treated if we were to come up with some kind of legislation or ordinance.
James Ed and then Mark?
John, I want to make sure I understand the state part, the 14-409.46. Basically, isn't that saying that any existing range, it doesn't matter what ordinance we change, it doesn't apply to them? Isn't that what that says? You can't bring nuisance noise.
So
It
right.
would all be prospective.
So
Unless there's a change in the range of the activities, a major change.
That is exactly what it says for noise and nuisance ordinances. A public safety ordinance would not fit within a noise or nuisance ordinance criteria. A nuisance law would be something like overgrown grass. Some cities have restrictions on letting your grass get a foot high. That's a nuisance law. Noise is a nuisance law. This state law prohibits neighbors from suing other neighbors, not just local ordinances, but approaching it from a public safety aspect would not be prohibited by this state law.
Thank you.
So I'm not comfortable with the subdivision density idea without knowing what it is. I think a house per acre is dense enough for the consideration of these issues. Maybe it's because I live in a house on 10 acres, and I imagine 9 houses on my 10 acres. That's a lot of people living right next to me.
So at least one house per acre?
Well, no, I think, then it's one house per acre here and there, but I think what you've used here is a good place to start, the 10 or greater.
Okay.
I wouldn't want to just have someone else decide without us knowing what the density is, and then we get these maps,
Right, and so I'll talk to probably Craig. He's probably got the people who can do this, but 10 or greater, we can leave that in place, but we can also look at whatever they can come up with as suburban and give you both of those and let you see what they look like.
Just one more clarification. So the sports shooting range, they're protected by state law.
From noise regulation, nuisance regulation, yes. The county can enforce a noise ordinance against those, but it's only going forward from the date of the ordinance adoption. It would not impact shooting ranges that were in existence at the time the ordinance is adopted or amended.
Okay, and we're not even looking at noise in this situation, because we already have a noise ordinance.
I did not, because we have talked about noise
In the
multiple
past.
times and
Right,
never, never decided to pursue that aspect, because, you know, really it only applies going forward.
Okay.
So the board has never, I think, has not asked for that recently. So, no, this does not include any look at noise.
Okay, Earl has another request.
Yes,
James Ed?
after all the comments.
Oh, okay.
Oh, okay.
I just wanted to ask our clerk to get a copy of that committee report for us new board members. Thank you.
Thanks.
Oh, yeah, sorry, we should have done that.
Yeah, we haven't seen that.
I think you're up.
Okay. We've got probably 20, 25 people here tonight. I guarantee you they're not here for the calendar discussion. As the board is aware, last Tuesday night, I made a request that we set aside our normal policy of not hearing from the public in a work session, and that is a policy. I don't know if it's written down, but it is policy. We don't take public comment in a work session. But I made a motion, as the board is aware, to set that aside. That failed. I'm going to make a respectful request tonight. These folks came tonight to listen. I don't know if anybody wants to speak or not, but they've been extraordinarily respectful. They've sat and they've listened to what we've said. Somebody might have a suggestion of a route, or somebody might have an opinion that's worth listening to. It is 8:45. If every person in a room speaks, we'll be out of here around 10. That's not an imposition on us. I would respectfully request that we set aside our policy of not taking public comment for this work session only.
Mark?
I'm in favor of moving ahead with what we decided the other night. We're going to discuss this issue at a later time. I don't think we should make rules on the fly. We don't want to do this at one work session, and all of a sudden we're going to the next work session. It's 11 o'clock at night, and we're trying to do work, and we're all of a sudden here and the staff for another hour. I think it's an unwise move, and we will have this issue concluded at some point in the not too distant future, and then we'll have something to comment on, and people will have ample time to comment on something that's actually specific.
Sally?
I was willing to entertain speaking at work sessions and a work session on this issue until I heard the conversation that we had last time, and I was persuaded that it's not a good idea to do it for some work sessions and not all work sessions, and I don't think we want to do it at all work sessions. What caused me to go back to thinking that we should not have comment at work sessions is the hope, and I would like to hear y'all's thoughts, but once we get through the next work session, or however many work sessions it takes to get comfortable with the staff bringing us back something that we can consider, that then we do follow Earl's suggestion, and we have a public hearing in which we don't make any decisions, but we hear all the public comment, because by that point we'll have a fairly detailed proposal in front of us, and then that we have at a later meeting. A meeting at which we vote, but even at that meeting, we would take public comment before we voted. That would be my proposed way of doing it.
That was suggested at the last meeting. As a matter of fact, Commissioner Green, or Sally, sorry, you recommended that we do 2 public hearings just to make sure that everyone got heard, and I believe everyone took that, and we would try to work that into the schedule.
Could I just make one comment on that? I think this should be part of our discussion on how we handle comment, because it's a much wider discussion. We can't pick and choose which issues get 2 public hearings. It's not for us to decide. There's a lot of people out there on a lot of issues that can't come to these meetings, that somehow don't have the information they need. I mean, we're focusing on one group of people. We need to look at how we make it easier for the general public on a wide range of issues to participate, and we shouldn't be the one who decide which are the hot button issues where we're going to have more
That's right.
public input than other issues.
And I would just add, as someone who's usually in favor of changing the rules, and Earl has chastised me on that several times when I was chair. I mean, one thing just to think about from a practical standpoint is people emailed about this meeting and were told there wouldn't be any public comment. And so I'm sure there's people who would have, if there was an opportunity to make public comment, might have come tonight, but because people were told you wouldn't have that opportunity. So that seems, that's, I'm saying actually back what I've heard from, and given that there's going to be more discussion about this, that's the other thing is that there people were email. We got a lot of emails about saying, can I come and comment at the work session? And we're told we don't take public comments at work session. And that's problematic if people got told no and are watching now and then said, oh, I could,
I just want to respond back to Mark down there that I don't agree that we can't decide when we need to have two public work sessions. I think we are sensible. We are responsive to what the public is asking us to do, and I don't think that just because we have to go down the road of having two public hearings for this particular issue, that obligates us to do it for all other issues, or that it means that we're inconsistent. I think it means that we're just being responsive to what we're hearing from the community.
And I would go along with what you're saying there. I think that if we get too rigid, we don't make any we make little progress. I think we can do a lot more and be more accountable to our constituency if we change as we need to change and suspend rules as we need to suspend rules. And I would just like also say that while we're still in this kind of in-between mode, we're still working on this, and I'll just speak for myself. Anyone that wants to call me or talk to me or email me with your ideas, I'm open. Just, information's online.
I had one. Can I just add? This is not related to this question, but it's something I forgot to say earlier about when you were summing up the potential next steps.
Sure. Can I just say one thing
go
about
ahead.
public comment? I think that what I'm hearing is that we might want to bring that in itself to a work session and talk about how we're getting information, how we're receiving information, and public comment in general. Are we covering what we need to be covering? Are we giving everybody the ability to speak with us? And if we're not, maybe we need to find different ways to go out and talk with the public differently. I don't think when you say at the work session that we don't want to have public comment that we're forcibly trying to shut people up. That's just the way that we've been doing it, is our policy. If we want to change it, we need to make a change. And I think that should be part of the discussion about the public comment and more of what Mark said. Please.
So I just wanted to say I forgot to say this. So one thing, and this is a broader conversation, it's not just related to this issue, but as you're looking at that map, one thing that would be, I think, important is, and maybe this is for the intergovernmental work group, or maybe this is part of this, but it would be good to know whether the towns have any future annexation or growth plans, because some of these high-density places, they're right on the borders of the existing limits. There's some on the south side of Hillsborough, and there's some on the southern part that are right on, it's not coincidence, right? That's where these densest areas are, is that they're
And
right.
Mebane, right?
Yeah.
Mebane also.
And so, and Mebane's got that crazy patchwork annexation. I don't even know how they did that. But, now they've just annexed the Medline thing. So I don't know that necessarily ties into the questions we've talked about already about whether or not we'll make any ordinance changes. But I do think part of the conversation, what this issue, one aspect of it is this question of the suburbanization of these fringe areas and how they're going to be, how they're going to be regulated generally.
Right.
Especially we're on the edges of town.
You're on this side of the street,
Right,
and you go
exactly.
over here, and you're on that side of the street, and suddenly you have different regulations, and you're, a foot
Yeah,
away.
there's always a line, right? You're on this side of the line, you're in the town. You're on the, you're across the street, you're out of the town.
Right.
you know, and so you get to vote for the mayor and you don't. I mean, we draw lines everywhere. So, but just looking at that map, it highlights that, you know, that the biggest squares or the biggest clusters of them are right on the, you know, right on the edges of the municipal boundaries.
Earl?
Yeah, Commissioner Dorson, you're correct. I have chastised you about making changes on the fly. I've been quite explicit occasionally, and I did it, and I don't regret it. I led off by saying that we had a policy that people could not speak at work sessions. I generally support that. Normally, our work sessions go to 10 or 10:30. This one's not. This one's stopping at about 9 o'clock. For me, it is a respect thing. For me, this board, this meeting belongs to this board. We can make any change that we want to make at any time we want to make it in any manner we so desire. That's within state law. So it's not a matter of could or should. We can. I also learned to count in the first grade. I see where the vote's going to be, and I don't intend to set my hair on
Don't
fire.
vote at work sessions either, so,
I know.
yeah.
Exactly. And that's why I'm not going to set my hair on fire.
Thank you. I think we have some next steps. John, are you okay with that discussion? I think my 9 went to 11 bullet points here. No pun intended, I'm sorry. Yeah, I know, that was bad. It's time to go home. I'll work with Greg, and we'll see what our calendar looks like as far as getting something back into a work session. But I think also we need to know what your timing's going to be. It seems like there's a lot of work here, just pulling up some of these maps and getting GIS and getting definitions, getting planning on board.
And I don't know how long it will take them to
Yeah.
come up with these various things, but probably at least a month before it's talked about again.
Okay. Well, we probably have our next work session already booked up, so we're probably looking at like 2 or 3 months out, I would assume. Is that right? Yeah. And then you could make your plea then, again.
Oh, you can assure I will.
I know you will. Sally, yeah.
Yeah, I do want to comment favorably on the permit idea. I think that would be a really good way to
I have that
regulate
written down as well, yeah.
the time that shooting can happen. That would go a long way to help some folks.
Any other comments?
Earl, you should make your request before the meeting if you want it to be changed, so that if we do change it, people will have notice
Yes,
in
notice.
advance of being at the meeting. That's something that I think is.
I made my motion last Tuesday night. It failed.
It failed.
Thank you all
motion
for
failed
coming
last
out.
Tuesday.
We appreciate your being here. You can email us at any time. Please feel free. It's the Orange County at BOCC, whatever. You can go on the website and get that address. Thank you.
Late filers.